Good evening. I'd like to welcome you to this public meeting of the New York City Rent Guidelines Board. This is just one meeting in a series of public meetings and hearings to determine renewal lease adjustments for rent-stabilized housing units in New York City with leases commencing or being renewed on or after October 1, 2018 and on or before September 30th, 2019. I will now take roll call. Please respond if present. Hillary Botine.
Present.
Rodrigo Camarena.
Present.
Shayla Garcia. Shayla? Present?
Oh, present. I talked to Jessica Yeager.
Leah Goodrich.
Present. I mean, she's
Cecilia Hosa.
present.
Angela Pinsky.
Present.
David Reese.
Present.
Scott Walsh.
Present.
Kathleen Roberts present. Let the record show that we have a quorum. The proposed rental adjustments voted at this meeting will be published in the city record and posted on our website, nyc.gov/RGB. 5 public hearings to comment on the proposed guidelines will be held on the following dates, times, and locations. Thursday, June 7th, a public hearing with public testimony at Jamaica Performing Arts Center Auditorium, 153-10 Jamaica Avenue, Jamaica, New York. (5:30 p.m. to 8:30 p.m. with interpretation available in Spanish. Monday, June 11th, public hearing with public testimony at the main theater of Hostas Community College, CUNY, 450 Grand Concourse, Bronx, New York, 10451, 5 p.m. to 8 p.m. with interpretation and simultaneous translation available in Spanish. Wednesday, June 13th, public hearing and public testimony at St. Francis College, Founders Hall, 1 Eddie Remsen Street, Brooklyn, New York, 5 p.m. to 8 p.m. with interpretation available in Spanish. Tuesday, June 19th, public hearing at the Great Hall at Cooper Union, 77th Street at the corner of 3rd Avenue in the basement, New York, 10003. From 4 p.m. to 8 p.m. Interpretation available in Spanish and Mandarin. Thursday, June 21st, public hearing at Oberia D. Dempsey Multi-Service Center Auditorium, 127 West 127th Street, New York, 5 p.m. to 8 p.m. Interpretation available in Spanish, and this location has the following accessibility options available: wheelchair accessible. Directions to these hearings can be found on our website, nyc.gov/RGB. Pre-registration to speak at these hearings will begin tomorrow at 9 a.m. You can sign up by calling the Rent Guidelines Board offices at 212-669-7480, then press 0 to register. For further information, see our website, and as always, there are copies of our meeting schedule here tonight. The next meeting of the board will be held on May 24th in the Landmarks Preservation Commission Conference Room, David N. Dinkins Municipal Building, 1 Center Street, 9th floor in Manhattan, starting at 9:30 a.m. The final vote will take place on June 26th, starting at 7 p.m. It will be held here in the Great Hall. Prior to taking any proposals from the board members, I will first read into the record the proposed language for apartment and loft order number 50 and hotel order number 48. I'm going to start with proposed order number 48. This is the proposed 2018 hotel order for hotels, rooming houses, single-room occupancy buildings, and lodging houses. Rent levels to be effective for leases commencing October 1, 2018 through September 30th, 2019. Notice is hereby given pursuant to the authority vested in the New York City Rent Guidelines Board by the Rent Stabilization Law of 1969 as amended, and the Emergency Tenant Protection Act of 1974 as amended, and is implemented by Resolution Number 276 of 1974 of the New York City Council, and in accordance with the requirements of Section 1043 of the New York City Charter, that the Rent Guidelines Board hereby proposes the following levels of fair rent increases over lawful rents charged and paid on September 30th, 2018. Applicability. This order shall apply to units and buildings subject to the hotel section of the Rent Stabilization Law, Sections 26-504C and 26-506 of the New York City Administrative Codes, as amended, or the Emergency Tenant Protection Act of 1974, 1974 Law 576, Section 4, 5A7. With respect to any tenant who has no lease or rental agreement, the level of rent increase established herein shall be effective as of 1 year from the date of the tenant's commencing occupancy, or as of 1 year from the date of the last rent adjustment charged to the tenant, or as of October 1, 2018, whichever is later. This anniversary date will also serve as the effective date for all subsequent Rent Guidelines Board hotel orders, unless the board shall specifically provide otherwise in the order. Where a lease or rental agreement is in effect, this order shall govern the rent increase applicable on or after October 1, 2018, upon expiration of such lease or rental agreement, but in no event prior to 1 year from the commencement date of the expiring lease, unless the parties have contracted to be bound by the effective date of this order. Proposed rent guidelines for hotels, rooming houses, single-room occupancy buildings, and lodging houses. Pursuant to its mandate to promulgate rent adjustments for hotel units subject to the Rent Stabilization Law of 1969 as amended, Section 26-510E of the New York City Administrative Code, the Rent Guidelines Board hereby proposes the following rent adjustments. The allowable level of rent adjustment over the lawful rent actually charged and paid on September 30th, 2018 shall be, and here there are 5 different categories as to which we will be voting later on in this proceeding. Residential Class A apartment hotels, lodging houses, rooming houses, Class B buildings containing less than 30 units, Class B hotels, and single-room occupancy buildings, MDL Section 248 SROs. New tenancies proposal. This is a blank for the moment. We'll be voting on this. Vacancy allowance is permitted under this order. Additional charges proposal. It is expressly understood that the rents collectible under the terms of this order are intended to compensate in full for all services provided without extra charge on the statutory date for the particular hotel dwelling unit or at the commencement of the tenancy of subsequent thereto. No additional charges may be made to a tenant for such services, however such charges may be called or identified. Statement of purpose, of basis and purpose. The Rent Guidelines Board is authorized to promulgate rent guidelines governing hotel units subject to the Rent Stabilization Law of 1969 as amended and the Emergency Tenant Protection Act of 1974 as amended. The purpose of these guidelines is to implement the public policy set forth in findings and declaration of emergency of the Rent Stabilization Law of 1969, Section 26-501 of the New York City Administrative Code, and in the legislative finding contained in the Emergency Tenant Protection Act of 1974, Chapter 576, Section 4, Section 2. This order, when signed, will be effective as of today, April 26, 2018. That concludes the language of the proposed order for hotels. I will now turn to the proposed apartment and loft order, which this year is number 50. Proposed order number 50, apartments and loft, rent levels for leases commencing October 1, 2018 through September 30th, 2019. Notice is hereby given pursuant to the authority vested in the New York City Rent Guidelines Board by the Rent Stabilization Law of 1969 as amended,
and the Emergency Tenant Protection Act of 1974 as amended, and is implemented by Resolution Number 276 of 1974 of the New York City Council, and in accordance with the requirements of Section 1043 of the New York City Charter, that the Rent Guidelines Board, RGB, hereby proposes the following levels of fair rent increases over lawful rents charged and paid on September 30th, 2018. These rent adjustments will apply to rent-stabilized apartments with leases commencing on or after October 1, 2018, and through September 30th, 2019. Rent guidelines for loft units subject to Section 286, Subdivision 7 of the Multiple Dwelling Law are also included in this order. Proposed adjustment for renewal leases, apartments. Together with such further adjustments as may be authorized by law, the annual adjustment for renewal leases for apartments shall be for a one-year renewal lease commencing on or after October 1, 2018, and or before September 30, 2019, and here is the blank which we'll be voting on. For a two-year renewal lease commencing on or after October 1, 2018, and on or before September 30th, 2019. Again, a blank there to be filled in when we conclude our voting. These adjustments shall also apply to dwelling units in a structure subject to the partial tax exemption program under Section 421A of the Real Property Tax Law, or in a structure subject to Section 423 of the Real Property Tax Law as a redevelopment project. Proposed vacancy allowance for apartments. There shall be, again here blank to be voted on, vacancy allowance. Proposed additional adjustment for rent-stabilized apartments sublet under Section 2525.6 of the Rent Stabilization Code. In the event of a sublease governed by Subdivision E of Section 2525.6 of the Rent Stabilization Code, the allowance authorized by such subdivision shall be, here again we'll be voting on what that allowance will be. Proposed adjustments for lofts, units in the category of buildings covered by Article 7C of the Multiple Dwelling Law. The Rent Guidelines Board proposes the following levels of rent increases above the base rent as defined in Section 286, Subdivision 4 of the Multiple Dwelling Law for units to which these guidelines are applicable in accordance with Article 7C of the Multiple Dwelling Law. For one-year increase periods commencing on or after October 1, 2018, and on or before September 30, 2019, and here we'll be voting on what that number will be. For two-year increase periods commencing on or after October 1, 2018, and on or before September 30, 2019, again here we will be voting on what that number will be. Vacant loft units proposal. There shall be, again, a blank vacancy allowance. We will vote on that. Fractional terms proposal. For the purposes of these guidelines, any lease or tenancy for a period up to and including 1 year shall be deemed a one-year lease or tenancy, and any lease or tenancy for a period of over 1 year and up to and including 2 years shall be deemed a two-year lease or tenancy. Escalator clauses proposal. Where a lease for a dwelling unit in effect on May 31st, 1968, or where a lease in effect on June 30th, 1974, for a dwelling unit which became subject to the Rent Stabilization Law of 1969, by virtue of the Emergency Tenant Protection Act of 1974 and Resolution Number 276 of the New York City Council, contained an escalator clause for the increased cost of operation, and such clause is still in effect. The lawful rent on September 30th, 2018, over which the fair rent under this order is computed, shall include the increased rental, if any, due under such clause, except those charges which accrued within 1 year of the commencement of the renewal lease. Moreover, where a lease contained in an escalator clause that the owner may validly renew under the code, unless the owner elects or is elected in writing to delete such clause, effective no later than October 1, 2018, from the existing lease, and all subsequent leases for such dwelling unit, the increased rental, if any, due under such escalator clause shall be offset against the amount of increase authorized under this order. Special adjustments under prior orders proposal. All rent adjustments lawfully implemented and maintained under previous apartment orders and included in the base rent in effect on September 30th, 2018, shall continue to be included in the base rent for the purpose of computing subsequent rents adjusted pursuant to this order. Proposed special guideline. Under Section 26-513B1 of the New York City Administrative Code and Section 9E of the Emergency Tenant Protection Act of 1974, the Rent Guidelines Board is obligated to promulgate special guidelines to aid the State Division of Housing and Community Renewal in its determination of initial legal regulated rents for housing accommodations previously subject to the city rent and rehabilitation law, which are the subject of a tenant application for adjustment. The Rent Guidelines Board hereby proposes the following special guideline. For dwelling units subject to the rent and rehabilitation law on September 30th, 2018, which become vacant after September 30th, 2018, the special guideline shall be, and we'll be voting on that momentarily. Decontrolled units proposal. The permissible increase for decontrolled units as referenced in Order 3A, which become decontrolled after September 30th, 2018, shall be, and again, we'll vote on that. Credits proposal. Rentals charged and paid in excess of the levels of rent increase established by this order shall be fully credited against the next month's rent. Statement of basis and purpose. The Rent Guidelines Board is authorized to promulgate rent guidelines governing apartment units subject to the Rent Stabilization Law of 1969 as amended and the Emergency Tenant Protection Act of 1974 as amended. The purpose of these guidelines is to implement the public policy set forth in findings and declaration of emergency of the Rent Stabilization Law of 1969, Section 26-501 of the New York City Administrative Code, and in the legislative finding contained in the Emergency Tenant Protection Act of 1974, Law of 1974, Chapter 576, Section 4, Section 2. The Rent Guidelines Board is also authorized to promulgate rent guidelines for loft units subject to Section 286, Subdivision 7 of the Multiple Dwelling Law. The purpose of the loft guidelines is to implement the public policy set forth in the legislative findings of Article 7C of the Multiple Dwelling Law, Section 280, and when entered, this will be effective April 26, 2018. Thank you for your patience. That's all legally required. All right. At this point, I would like to turn to proposals with respect to rental adjustments for rent-stabilized hotel units. And I will turn first to our tenant members.
Thank you, Kathleen. I first want to start off by thanking all of you for being here tonight. I know that you all are coming from work, had to make arrangements to be here, so I wanted to say thank you for coming to participate in this process. That's really important. I know many of you are here to hear what happens to rent-stabilized apartments, but there is a large group, a huge population of people living in what we call hotels, rent-stabilized apartments, and so we're going to be making a motion for one of the most marginalized communities in the city, folks that are living in what is a hotel room size apartment and are paying extraordinary amounts of their incomes in rent. And so it is the marginalized folks in the city. Those are folks who are living on their own, and if they're a couple, those are apartments that are even, think about a hotel room size, and that's like your living space. And so it's really important that we acknowledge that for the last few years, we've had not only 0% increases for those hotel apartments, which has been the right thing to do, DHCR's own data is stating that we are losing that kind of housing at unprecedented levels. They're saying that there are 10,872 apartment rents, hotels left. That is a really small number if you compare it back to where we were 20 years ago. And the reason why it's so important to watch what's happening to hotel apartments is because we don't want the same thing to happen to rent-stabilized units. We want to make sure that we're protecting those units as well as protecting the rent-stabilized units as a whole. That is why tonight I am making a motion to propose that the rental adjustments for rent-stabilized hotel units.
You do need a second.
Oh.
Sorry, I was just checking.
Yet.
It's okay, sorry.
Okay. I haven't even said anything. I move to adopt the language of proposed Hotel Order 48 as read into the record at this meeting, and I move to adopt the following proposed rental adjustments for rent-stabilized hotels. Residential Class A apartment hotels, 0% increase. There's 4 more. Hotel lodging houses, 0% adjustment. Rooming houses, Class B buildings containing less than 30 units, 0% adjustment. Class B hotels, 0% adjustment. Single room occupancy buildings, 0% adjustments. And there should be no vacancy allowance permitted under this order. Therefore, the rents charged for the tenancies commencing on or after October 1st, 2018, and on or after September 30th, 2019 may not exceed the legal levels over rental charged on September 30th, 2018, permitted under the applicable rent adjustments provided above. To summarize, in accordance with my motion, you are voting on adjustments I proposed and the proposal language in the order.
Okay, is there a second?
I second the motion.
Thank you. Any discussion? Anyone wish to be heard? All right. Then we will proceed to vote on the motion by the tenant members. I will ask first Hillary Bochin.
Yes.
Rodrigo Camarena.
Yes.
Shayla Garcia.
Yes.
Leah Goodridge.
Yes.
Cecilia Hosa.
Yes.
Angela Pinsky.
No.
David Reese.
Yes.
Scott Walsh.
No.
Kathleen Roberts, yes. The motion is carried. All right, at this time, we'll move to proposals with respect to adjustments for rent-stabilized apartments and lofts. And once again, I'll turn first to our tenant members. And by the way, I would like at this moment, I neglected to do it earlier, but I want to especially welcome the new members of our board. That includes Leah Goodrich, a tenant member. Rodrigo Camarena, a public member, and Angela Pinsky, an owner member. Thank you. Go ahead.
So, as I was mentioning earlier, I think that rent-stabilized housing stock in New York City is extremely valuable. It actually allows us to keep rents low overall for tenants in the city. It actually allows us to have a diverse community that we all love. We all love living in New York City because of what it means to live here, the communities that we've been able to create, and we want to be able to remain in them. So I'm gonna just I'm just going to highlight some of the data that we've seen this year. So 59,467 people are sleeping every night in shelters. That is what's happening in the city we call home, in the city that we love. You know, a ton of those population are small children. Over 12,000 of them are families. That is not right. That is not the city we want to be living in. 56% of tenants living in rent-stabilized housing are paying over 30% of their income in rent. That means that people in the city are severely burdened by rent. 30% of folks are paying over 50% of their income in rent. Is that right? While on the other hand, we've seen transportation for people in the city increase. We've seen unemployment maybe give us a nod in the right direction. But that doesn't mean that tenants overall are seeing an increase in their income, in their daily lives, because inflation is actually outpacing what they're actually seeing in their pockets. We don't want to have this be another year where landlords continue to see their overall money in their pocket to increase when tenants overall in the city are in hardship. That is why we're actually going to talk a little bit about how landlords are struggling in the city. So the data doesn't actually prove that, right? Landlords, there's not more foreclosures than the previous years. The housing stock is healthier than it's ever been. It's true. I think that the other things to highlight is that overall landlords are just doing okay. That it's fine. We want the housing stock, we want the business to be profitable for landlords, but not at the cost of tenants and not at the cost of mass displacement of people who live in the city. The last few years, we've seen unprecedented historic lows. For the 2014, we saw 2 rent freezes. And then we saw last year the rents increase. It was what we call on the board a modest increase, but for tenants, a huge increase in their daily lives, a shift on how they have to behave and what they can do with their money. So I want to just make sure that we are all on the same page on that. Tenants aren't doing necessarily better. They're still seeing increases from MCIs, IAIs, fees, third month rents, continue harassment in their buildings, having to organize. And as a board, we need to recognize that all of that time that you all spend opposing MCIs and losing them, making sure that that your landlord is charging you money, the right amount in rent, all of that time is not time we recognize as work. And it is a lot of work, and that's why you all are here tonight. So a lot of people talk about, what about landlords? What about the small landlords? What about the cost for landlords? Well, we haven't seen any data that says that landlords overall are struggling. DHCR had 2 hardship applications submitted. Both were denied because they did not find grounds for hardship. That means that landlords could be doing what we do when we have no heat and hot water, apply for a reduction. When we have to fight an MCI, and when we have to be in our buildings knocking on doors to make sure that we get decent housing conditions. So our mandate as a board is to make sure that we're stimulating a fair housing market. The housing market in New York City is not like any other in the country. There is no housing stock where you can't negotiate and barter with your landlord. Here, they know they can make a profit and they know that they can charge whatever they want in housing. Because we're at a housing crisis, less than 4% vacancy, which is why rent-stabilized housing exists. So when we're making a decision tonight, when you are all asking for a 0, there's not a 0 based on let's feel bad for tenants. It's based on data that we have seen over and over again, which is why I'm making the motion. I never know how to put this in. It's like, how do you read this? which is why I'm making the motion for a proposal rental adjustments of rent-stabilized tenants and loft. I move to adopt the language proposed for apartment and lofts, order number 50, as read into the record at this meeting, and move to adopt the following proposed rental adjustment for rent-stabilized tenants and lofts. For 1-year leases, 0 to... I have to finish the second part.
We need to hear the proposal.
So just a reminder that the proposals tonight are arranged for apartments. So I will be saying 2 numbers for each 1-year and 2-year leases. So that means that my suggestion is that we should be voting as a board between those 2 numbers. The first one for 1-year lease is 0% to 1.5%. For 2-year lease, 0 to 2%. No. My proposal is no sublet allowance, no vacancy allowance permitted except as proposed by the Rent Regulation Form of Act 1997 and the Rent Act of 2015. For loft, the same. For 1-year leases, 0 to 1.5. For 2-year leases, 0 to 2. No vacancy allowance.
Let's let her make her proposal, please.
Same language as in the current.
Okay. So no vacancy allowance, same language as what's in the order right now. Special guideline of 0% above the maximum base rent. To summarize, in accordance with the motion, you are voting in adjustments I proposed and the proposed language in this order.
Is there a second?
Good evening, New York. I just want to say how happy I am to represent the tenants. I have a job where I see the after effects of high rent every day. I'm a tenant's attorney. I'm in housing court fighting eviction. And who do we see? We see seniors, we see young families, we see young mothers, and the majority of the time, people are getting evicted because they cannot afford the rent. And what ends up happening, these folks end up in the shelter system, and that ends up costing the city much more than it would have been to just have lower rent. So what do we want? When do we want it? I second the motion.
Is there any discussion on the pending motion before we take a vote? No discussion? All right. Hillary Botín.
No.
Rodrigo Camarena.
No.
Shayla Garcia.
Yes.
Leah Goodridge.
Yes.
Cecilia Hosa.
No.
Angela Pinsky.
No.
David Reese.
No.
Scott Walsh.
No.
Kathleen Roberts votes no.
The motion is defeated. We'll move now to a proposal from the owner representative.
time to proceed. Okay, let's proceed, please. Scott, you have a proposal? Go ahead and make your proposal, please.
Okay, can we have quiet for a minute?
Please,
Can we
please, be
have quiet?
respectful.
Okay. Are we ready? But if people can't hear it, what's the purpose in doing it?
Please come to order. This is a public hearing. At this time, I'd like to put forward a motion for proposed rental adjustments for rent-stabilized apartments and lofts. I move to adopt the language of the proposed apartment and loft order number 50 as read into the record at this meeting, and I move to adopt the following proposed rental adjustments for rent-stabilized apartments and lofts. For apartments, for a one-year lease, 0.75 to 2.75. For a two-year lease, 1.75 to 3.75. With a sublet allowance of 10%. No vacancy allowance is permitted except as provided by the Rent Regulation Reform Act of 1997 and the Rent Act of 2015. Lofts, one-year lease, 0.75 to 2.75. Two-year lease, 1.75 to 3.75. Vacant loft units, no vacancy allowance is permitted under this order. Therefore, except as otherwise provided in Section 286, Subdivision 6 of the Multiple Dwelling Law, the rent charged to any tenant for a vacancy tenancy commencing on or after October 1, 2018, and on or before September 30th, 2019, may not exceed the base rent referenced above, plus the level of adjustment permitted above for increased periods. Special guideline, 39% above the maximum base rent. To summarize, in accordance with my motion, you are voting on the adjustments I propose and the proposed language of the order. Is there a second?
A second.
Is there any discussion? I'm going to call you this meeting.
I second.
She seconded. I'm now going to take the vote. Okay. Hillary Botín.
Yes.
Rodrigo Camarena.
Yes.
Shayla Garcia. Shayla, how do you vote?
No.
Leah Goodrich.
No.
Cecilia Hosa.
Yes.
Angela Pinsky.
No.
David Reese.
Yes.
Scott Walsh.
No.
Kathleen Roberts, I vote yes. The motion is carried. Do I hear a motion to adjourn?
A second.
Is there a motion to adjourn? Is there a second? Do you second the motion to adjourn? Okay, we are adjourned.